Hi, I'm Dave Kopel, Research Director of the Independence Institute in Denver, Colorado. Today I'd like to talk about U.S. Supreme Court history on the right to bear arms, and to focus on the most important case the Supreme Court decided in the 19th century, and still one of the most famous cases today. That is the 1856 case of Dred Scott v. Sandford. Now, if you'd like some background on the case, my scholarly friend David Hardy has written an excellent book on the topic that goes into all the background, and he details how Dred Scott was actually a test case brought by anti-slavery folks. Well, it was a test that went pretty badly because the result in the Supreme Court was disastrous for the rights of black people in general, and including free black people. But the case does show a lot about how the court and the public understood the right to keep and bear arms at the time and thereafter. Dred Scott was suing Sandford in what is called diversity jurisdiction. That's provided in the United States Constitution for federal courts, and it involves a suit between a citizen of one state versus a citizen of another state. Now, the question is, you have to have diversity of jurisdiction. You can't have two citizens from the same state suing each other, nor can diversity jurisdiction be invoked by someone who is not a citizen of the United States. Now, if the Dred Scott Court had had the advantage of Lexis and Westlaw like we do today, they could have looked at cases from the 1790s where federal courts absolutely said that free blacks were citizens of the United States, in the sense that they could bring diversity lawsuits in federal courts. But without the research, and perhaps with a lot of bias, the majority of the Supreme Court ruled that even free blacks in the United States, born and raised here, were not citizens of the United States. They might be citizens of the state where they lived, but that was up to the state, but they weren't United States citizens. And in making that argument, Chief Justice Taney, who wrote the Dred Scott opinion, gave his list of the unacceptable policy consequences that would happen if free blacks were recognized as citizens. If they were, then they would have, under Article 4 of the U.S. Constitution, the privileges and immunities of citizens of the United States. What are these privileges and immunities of citizens of the United States? Well, he said if they were free blacks were citizens, they'd have the right to enter any state, to stay there as long as they pleased, and within that state they could go where they wanted at any hour of day or night, unless they committed some act for which a white person could be punished. Further, black citizens would have, quote, the right to full liberty of speech in public and private upon all subjects which a state's own citizens might meet, to hold public meetings upon political affairs, and to keep and carry arms wherever they went. The right to keep and carry arms wherever you go is one of the privileges and immunities of citizens of the United States. Now, Dred Scott created a lot of controversy with its holding that free blacks were not citizens, but it created even more controversy with its second holding, that the 1820 Missouri Compromise was unconstitutional. The Missouri Compromise had banned slavery in federal territories north of the 38th parallel, such as the future state of Nebraska. And Chief Justice Taney said that was unconstitutional because it was a violation of the property rights, so-called, of the slaveholders who wanted to bring their slaves into a territory. To make that argument, Justice Taney started with something that was universally agreed by everyone, which is the federal government, when it's legislating for federal territories, can't violate the rights of United States citizens in the territories. Here's what he said. No one, we presume, will contend that Congress can make any law in a territory respecting the establishment of religion or the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people of the territory peaceably to assemble and to petition the government for redress of grievances. Nor can Congress deny to the people the right to keep and bear arms, nor the right to trial by jury, nor compel anyone to be a witness against himself in a criminal proceeding. So right there, he goes through a litany of the rights in the Bill of Rights, says Congress can't violate them for the people in the territories, and he includes in the rights the right to keep and bear arms. Now, this kind of shows the silliness of the theory that became popular in some quarters in the last part of the 20th century, that the Second Amendment isn't a right of individual citizens, it's only a right of state governments, it's only a right of the militias. The view here is just the opposite. It's the right of all citizens in the territories, just like the rest of the Bill of Rights is. Now, the Dred Scott case caused a sensation and a furor in the United States, and it led, in significant part, was a major cause of the Civil War. And the Civil War led to the abolition of slavery. But what was going to happen after the Civil War? Well, on May 10th, 1865, the great Frederick Douglass gave a major speech in New York City addressing exactly that issue. It was titled, "In What New Skin Will the Old Snake Come Forth?" And what I'm about to read was quoted by Justice Clarence Thomas in his concurring opinion in the case of McDonald versus Chicago. Douglass predicted that even though formal slavery was certainly going to be abolished, the former slave states would try to find ways to keep the black population in a state of de facto servitude, and part of that would be preventing them from keeping and bearing arms. He talked about what needed to be changed and why there was a constitutional amendment. That not only did we need a constitutional amendment against slavery, we needed another constitutional amendment to protect the civil rights of all people, including free people of color. Because without that, said Douglass, the legislatures of the South can take from him, the former slave, the right to keep and bear arms as they can. They would not allow a Negro to walk with a cane where I came from. That was Maryland. They would not allow 5 of them to assemble together at night. Douglass continued, notwithstanding the provision in the Constitution of the United States that the right to keep and bear arms shall not be abridged, the black man has never had the right either to keep or bear arms. And he said until there was a new constitutional amendment to make the states obey the Second Amendment, the work of the abolitionists is not finished. Well, the abolitionists made a lot of progress by passing the 14th Amendment in Congress in 1866 and then getting it ratified by the states in 1868. But that work still took a long time because it was not until 2010, in the case of McDonald versus City of Chicago, brought by the Second Amendment Foundation, where the U.S. Supreme Court finally said that states do have to obey the Second Amendment. Now, that case involved Otis McDonald, Rhonda Ezell, and other good citizens of Chicago who wanted to have handguns in their home for lawful protection. And even today, states such as New York, New Jersey, or Maryland, Douglass's old state, will at least grudgingly allow people to have handguns in their home for lawful protection, but they still won't allow people to carry handguns for lawful self-defense. In other words, people like the plaintiffs in New York State Rifle and Pistol Association versus Bruin, currently before the Supreme Court, are fighting over the same kind of issue that was going on in Dred Scott. They say, look, we're citizens of the United States. The Second Amendment protects us. The Second Amendment protects the right to bear arms. And the 14th Amendment means that state and local governments have to obey the Second Amendment. And you still won't let us even get a permit to carry a firearm. Back in the Dred Scott days, Chief Justice Taney didn't think that people needed permits. He said you can keep and carry arms wherever you go if you're a citizen of the United States. And the plaintiffs in the Bruin case aren't even asking for that. They're just asking to be able to go through a permitting process to be able to exercise their right to bear arms. So these issues that were contested in Dred Scott in 1856 are still at issue today in 2021. Because as it turns out, civil rights are not something you win once and for all and then you're set. There's a continuing struggle to fight for civil liberties. If you'd like to learn more about these issues, well, please come to my website, davekopel.org, where I've got all sorts of historical, legal, and other scholarship for you to read, much of it for free. Please buy my books. I could use the money, and some of the books are listed behind me, including the brand new 3rd edition of my law school textbook, Firearms Law and the Second Amendment, which has been quoted by then Judge Kavanaugh when he was on the D.C. Circuit and Judge Hardiman of the Third Circuit. You can follow me on Twitter at Dave Kopel. I put out a twice-a-day newspaper, Kopel's Law and Liberty News, which aggregates content from all over the United States. And I do more videos on Independence Institute Television, so please come back and thank you.